Hello and welcome to my presentation on the law regulating leases and in particular leasehold covenants. Today I shall be critically analysing the law, the current issues surrounding leasehold covenants and suggesting potential reforms in order to improve the law. The Law Commission states that the law on leasehold impacts the lives of millions of people, whether they are landlords, tenants of homes, farms or businesses, meaning that it is a critical aspect of land law. However, before a critical analysis can begin, it is necessary to establish what a leasehold covenant is. A lease is a form of contract between two or more parties, and therefore, being a contract, will contain terms called covenants. Leasehold covenants are either expressed, i.e. they're specifically stated in the lease, or implied, meaning that they are not specifically stated, but they are assumed to be true by all parties concerned. Throughout this presentation, I shall be critically analysing the current law on a landlord's covenant fit for habitation, the law of forfeiture, and leases signed before January the 1st, 1996. The first area of leasehold covenant law that I believe to be in need of reform in the near future is the uncertainty surrounding a landlord's covenant to maintain the property fit for habitation. Under current UK law, there is no implied covenant for landlords to ensure that their leased premises are fit for habitation. Despite this, there are circumstances where landlords are required to make the premises fit for habitation, making the law unclear and often confusing with regard to whether or not a tenant knows if his lease should be made fit for habitation by the landlord at the start of the lease. Now, the first issue with this current law comes from the decision in the case of Smith and Marrable in 1843, where a common law obligation was placed on the landlord, stating a furnished house must be fit for habitation, which was further supported by the case of Wilson and Finch Hatton in 1877. However, this obligation only relates to the condition of the premises at the commencement of the letting and has no effect on unfurnished premises and only applies to residential tenancy. Now, the issue here is that the law is unnecessarily confusing and raises numerous avoidable issues, such as what constitutes a furnished premise and residential tenancy. These issues contribute to the lack of clarity with regard to the covenant of fit for habitation. Furthermore, along with a common law obligation, there is also a statutory obligation imposed on landlords to ensure their premises are fit for habitation under Section 8 of the Landlord and Tenant Act 1985. This states that a dwelling house will be fit for habitation at the start of and throughout the tenancy. So the issues that we have is the confusing and complex realisation that there is a common law and a statutory obligation on fit for premises, yet no implied covenant. The main cause of these issues is that both common law and statutory obligations only refer to human habitation. In order to make the law clearer and less confusing for both landlords and tenants entering in the lease, I suggest reforming the current standpoint of no implied covenant on making landlords' premises fit for habitation and changing it so that there is an implied covenant. This will remove the conflict between statute and common law judgments and the current lack of necessity to ensure premises are fit for habitation. I also suggest that there should be an implied covenant unless it is expressly stated that the premises is not going to be used for residential tenancy, in which case there should be no implied covenant. I believe that residential tenancies are at the heart of the issue, as both common law and statute look to protect residents, yet the current law concerns all leases, meaning that there is no implied covenant. My suggested reform removes the need for common law and statutory obligations, thus making it simpler and clearer. Another area of law regarding leasehold covenants in need of reform is the process of forfeiture. The term forfeiture was described by Lord Justice Fox in Clays Lane Cooperative against Patrick in 1984 by stating, a right to determine a lease by a landlord is a right of forfeiture if A, when exercised, it operates to bring the lease to an end earlier than it would naturally terminate, and B, it is exercisable in the event of some default by the tenant. The main issue with the law of forfeiture, much similar to the issue of the covenant of fit for habitation as I previously mentioned, is that the law is unclear and lengthy, but moreover does not provide an